Centre's decision to bar overseas citizen of India students from general seats will apply to only those who register as overseas citizen of India's students after 4/3/2021. This is the Supreme Court order ruled on 3rd February 23 in a 75-page judgment. Hello medical aspirants, welcome to my YouTube channel. Here is an update from the Supreme Court of India regarding the overseas citizen of India students' claim to compete general quota seats in professional courses. Its decision to prevent bar the OCA students in claiming will have only prospective effect and will not have any retrospective effect. This means OCA students who are born after 4/3/2021 and OCA students who get the status of OCA after 4/3/2021 alone will be covered under this regulation and clause. All other OCA students are allowed to compete general quota seats born prior to 4/3/21 and who gained the status prior to 4/3/2021. This is the judgment, 55-page judgment delivered by the Supreme Court of India on 3rd February 2023. Way back in 2021, the Ministry of Home Affairs notified a gazette stating overseas citizen of India students will not be entitled for government quota seats meant for Indian students, and they will be accommodated only in the NRI quota seats and the supernumerary seats. The reason cited in the regulation is that these students are possessing foreign passport and therefore they will be considered only as foreign students and not Indian citizen. However, the Supreme Court of India last May 2022 issued a interim direction that students belongs to 2021-22 will be allowed to compete general quota seats, and this concession will not be extended furthermore to students. And the case is heard all rounds in the Supreme Court of India. The Supreme Court in its order stated that the OCA students to compete general quota seats will have only prospective effect and will not have any retrospective effect. Judgment in the description box link, and we will look into the details of the court case. This is the Gazette notification containing the clause that the OCA card holder shall not be eligible for admission against an reserved exclusively for Indian citizens. Actually, this clause was challenged before the Supreme Court of India by a batch of OCA students. The Supreme Court on Friday, that is on 3/2/2023, held that the notification issued by the central government in 21, which took away the rights of overseas citizens of India category students to apply for general seats and confined their right only to non-resident Indians category seats, will apply only prospectively from the date of the notification, which is March 4/21. The notification issued by the Ministry of Home Affairs on March 21 stated that OCA students can only apply to NRI seats or supernumerary seats for all India entrance tests like NEET, G Mains and G Advanced, and barred them from applying to seats exclusively reserved for Indian citizens. Delivering judgment on petitions filed Challenging these restrictions, the court held that the provisions of the notification shall apply prospectively only to persons who are born in a foreign country subsequent to 4/3/21, that is, the date of the notification, and who seek for a registration as OCI card holder from that date. The court further held that the petitioners in all these cases and all other similarly placed OCI card holders will be entitled to the rights and privileges which had been conferred on them earlier to the notification dated 4/3/21 and could be availed by them, notwithstanding the exclusion carved out in the notification dated 4/3/21. This means that the rights of those who are OCI card holders till 4/3/21 will not get affected, and all pre-existing rights are saved. The court had earlier passed interim orders allowing certain OCI petitioners to apply for general category seats for 21-22 academic year. These admissions have been regularized, said Justice pronouncing the judgment. The court observed in the judgment that the notification suffered from non-application of mind, as it had the effect of retroactively taking away the rights of those who had secured OCI cards before 4/3/21. The judgment was pronounced in a batch of petitions filed by OCI students challenging the 21 notification. A bench of justice heard the matter. Though the impugnant notification dated 4/3/21 is based on a policy that in the exercise of the statutory power of a sovereign state, the provisions as contained therein shall apply prospectively only to persons who are born in a foreign country subsequent to 4/3/21, that is, the date of the notification, and who seek for a registration as OCI card holder from that date, since at that juncture the parents would have a choice to either seek for citizenship by descent or to continue as a foreigner in the background of the subsisting policy of the sovereign state. More petitioners had completed their education in India, unfair to ask them to go back to their birth nation now. The court noted that most petitioners had completed their entire school education in India, despite their birth in a foreign country. It further noted that the central government had been expanding the rights bestowed on OCI card holders through its previous notifications issued in 2005. These rights were conferred in exercise of powers under Section 7B of the Citizenship Act 1955. In this background, though the doctrine of legitimate expectation may not apply strictly, the court observed that the statutory right conferred had sown the seed of hope, recognizing the affiliation to this country. Having undertaken the entire educational career in India, or at least the high school onwards, they cannot at this stage turn back to the country in which they were born to secure the professional education, as they would not be in a position to compete with the students there, either keeping in view the study pattern and the monetary implications, the court stated in the judgment. Statutory rights should not be withdrawn in an arbitrary manner. The court stated the right of the OCI card holders is a midway right in the absence of dual citizenship. When a statutory right was conferred and such a right is being withdrawn through a notification, the process for withdrawal is required to demonstrate that the action taken is reasonable and has nexus to the purpose. It should not be arbitrary, without basis, and the exercise of such power cannot be exercised unmindful of consequences merely because it is a sovereign power. The center's justification was that the move was intended to protect the admissions for foreign Indian students. However, the court said that except a bare statement, there is no material with regard to the actual exercise undertaken to arrive at a conclusion that the participation of OCA card holders in the selection process has denied the opportunity of professional education to the Indian citizens. The court formed the opinion that there are rights accrued to OCA students who had been living in India for past several years. The judgment illustrated the case of a petitioner who had been living in India since 2003, which cannot be retroactively taken away abruptly. The goalpost is shifted when the game is about to be over. Hence, we are of the view that the retroactive operation resulting in retrospective consequences should be set aside and such adverse consequences is to be avoided, the court held. The court also expressed the view that the future application of notification should be relooked by the higher echelons of the executive, having regard to the wide ramifications on the Indian diaspora. Last year, the Supreme Court had passed an interim order allowing OCA card holders to apply to general seats for NEET admissions. However, the court had clarified that the interim order was confined only to the 21-22 academic year. In the present academic year, instead of granting interim relief, the Supreme Court said that it would hear the matter at length and finally decide the same. Arguments during hearing. Referring to the judgment in Maneka Gandhi versus Union of India, senior advocate appearing on behalf of the OCA students had submitted that while classification is allowed, micro-classification has been frowned upon by this court. He had pointed out that while those who with OCA status are eligible only to NRI seats, NRIs can apply for NRI as well as Indian seats. It had been argued that till 2020, the OCA students were considered. Senior advocate appearing for students who are born to OCA parents and have been residing in India had submitted that OCAs can't be compared with non-resident Indians as the NRIs are living abroad and are earning in foreign currency. The senior counsel explained that OCA was a concept introduced by the Government of India in 2005 to confer certain rights to persons of Indian origin who may have foreign citizenship. The scheme was floated to encourage them to settle in India and seek their services here. In some cases, children may have obtained foreign citizenship when they were born abroad while their parents are working there. They might have returned to India later. They might have been brought up in India but still have the OCA status due to their foreign citizenship. It had been also emphasized on that the percentage of NRI seats in medical admissions is very less and the fees for such a seat is exorbitant, which can't be afforded by OCA students living in India. ASG appearing for the Union government submitted that the petitioners are trying to compete in the seats meant for Indian citizens who have no avenues outside, whereas the OCA students can get citizenship rights abroad. During the course of the hearing, the bench had asked the senior counsel for the OCA students why they are not giving up their foreign citizenships to compete in the general category for admission to medical colleges. The counsel addressed the concern raised by the bench by submitting that the petitioners are not seeking conferral of any new rights but the continuation of the benefits which were being given till 21. In this regard, he had referred to Section 7B of the Citizenship Act 1955, which states that the OCA persons are entitled to the rights specified by the government. Since the rights had been in existence for long, there is a legitimate expectation and the sudden withdrawal of the rights is arbitrary. It had been asserted many OCIs chose to settle in India on the basis of the rights conferred under Section 7B. The Council had contended that the centre's notification is painting all OCIs with the same brush without considering persons who have been residing in India for long. These are all the court proceedings and the contents of the judgment delivered on 3rd February 23. Thanks for watching. For updates, subscribe to my YouTube channel. Thank you.